I have a disability. When the judge makes it sound like I'm guilty before I'm found guilty, I'm triggered. I have a disability. When the state is trying to unlawfully prosecute me, I trigger. That's a disability. When the judge tries to talk down to me, that's a disability. When the judge assumes, that's a disability. When the judge makes it up, that's a disability. And it's actually a disability by the judge, and they should be removed from the bench. So not only will everybody be watching, it'll be live streamed around the world. And if you try to take away I need my secret girlfriends in Australia, in Europe. I have more than one wife, okay? I have internet wives, okay? Okay? I have an emotional support staff in multiple languages. I have women of all ages who tell me, calm down. But I don't need to be told to calm down because you're going to not trigger my disability. If you've been kidnapped in court for talking, you know. And when we listened to this hearing from the other day and the judge mute me when I was trying to talk and fire my lawyers in open court, me and this judge already are starting off on the wrong foot. Just play dumb right now. Let's just play dumb right now and act like we want the fucking. Okay, watch this. So, ADA accommodations. Is ADA in the chat or not? Yeah, we're gonna call the ADA coordinator right now. Make sure you send Kent Wahlquist so he can watch live.
District Court, this is Kim.
Good morning, Kim. My name's Lane Myers. I'm calling you because you're the ADA coordinator, right?
Yeah, I am.
I'm requesting ADA accommodations for my hearing at 1 o'clock in the Los Alamos Magistrate Court with Catherine Taylor.
Okay. So it's a little short notice, so it kind of depends on what it is that you need.
No, I'm going to get whatever I need on short notice because it was also short notice for me. I found out about the hearing about less than 12 hours ago. So.
Okay.
So
I'm sorry. Do you have a case number I could at least look up?
For sure. Okay, sorry.
What is that?
My lawyers were handling it before, but I had to get rid of them because they suck.
Okay.
And so now, or actually, let me not get sued defamation. They fired me, didn't you guys? You fired me. Anyways, sorry, I didn't want to. All right, so number M. You ready? Here we go. Like I said, I was out of the loop in this case for a while. Now I'm back in it. So now we're gonna be claiming the ADA early and often. And so M33 MR 2024 00017. My name is Lane Myers.
Okay, I'm sorry, Lynn. Can you hold on 1 second? Can you give that to me one more time? M33 MR
2024
Yep. 00017.
17.
I'm sorry. Thank you. All right, Lane Jeffrey Myers. I found it.
Yes, that's me.
Okay, and right, you have a motion hearing, it seems, today at 1 o'clock. Yes.
I don't know why, because those motions are withdrawn and thrown in the trash where they belong, but we're gonna play the game with you guys.
Okay, so I mean, the judges are required under certain rules to schedule, hearings.
No, I don't need legal advice, ma'am. One thing I don't need is legal advice. So here's the deal. We're testing you. You're not testing me, okay? You're under the microscope right now, not me, right? Okay? And so here's the deal. I found out about this hearing yesterday about 2 p.m. Okay? Well, I need my ADA accommodations, okay? And what I'm saying is that right now the first ADA accommodation I need is the for the court clerk at the Los Alamos magistrate to stop hanging up on me halfway through my first sentence. Okay, so we'll start with the first ADA accommodation is hear me out. Let me speak. Okay, beyond 3 words where you hang up on me live on the live stream for the whole world to see her being rude. Okay, so now I've already been hung up on 4 times today, about 12 times yesterday. This is not off to a good start, okay? We're off to a bad start. I'm telling you right now, as the ADA coordinator, my disabilities have already been triggered by these unlawful, unethical, unprofessional behaviors of the court staff, okay? So we'll start there. My first accommodation...
Sir, can I mention one thing?
For sure.
Okay. I would appreciate it if you can, to not yell.
I'm not yelling. You're on speakerphone. You're on speakerphone. I'm not yelling.
Well, okay.
I'm conducting a live stream, ma'am. This is the way it is.
Upset.
I am not upset. Whoa, 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 ADA accommodation coordinator. Do not ever in your entire life project your opinions into my actions. I am not upset. This is me 24/7. You'll know when I'm upset because I'll be calling you names you don't want to be called, okay? And right now I'm talking to you. This is how I talk. I don't have good hearing. I'm very direct. I talk loud, whatever. I'm not yelling. This is my style. You want to like, share, and subscribe. You can go on the internet right now and pull yourself up and listen to yourself on this call right now, live on the internet. So what I'm telling you is right now, I need you to be the best version of Kim Moore, ADA coordinator, okay? That's what I need from you. I need you to understand that you work with people that are disabled. Right now, you're triggering my disability. You're not accommodating my disability, okay? And so for the best thing you could do is let me tell you the accommodations I need, and then we come to a reasonable conclusion about those accommodations taking place today, okay? So back to the beginning, the first accommodation...
Sir, one thing, though, can also speak occasionally.
Who, you?
Right? Yes.
Yeah, you could, for sure, but you just can't interrupt me, okay? And you can't, and you're interrupting me right now, ma'am. I have a disability. You're triggering it. You're the ADA coordinator. You don't get to tell me how to manage my disability that I can't control, okay? It's a disability. That's why I'm speaking accommodations. I have a disability, okay? I'm not perfect. I don't take direction well from people. So let's get back to the beginning. My ADA accommodations that I need is, the first one I need is all court staff, court employees, judges, support staff, court administration to carry out the proper scope of their job duty, hear out the public, not hang up on them, not try to do things in the dark that are going to come to the light, and do not try to weaponize anything against me with the court systems by hanging up on me and delaying and denying. Because right now I haven't even been served the motions, and I call down there and I asked to have them served, and they hang up on me. So I'm telling you right now, Kim Moore, ADA coordinator, it's a lawsuit because they're triggering they're not accommodating my disability where I need to be told what's going on in the case so I can prepare. Okay, I'm the lawyer now. Okay, so I don't need to have them hanging up on me. Okay, because all that's going to do is I'm going to give out the number, and there's going to be thousands of people calling. Okay, asking why are you messing with Lane? Okay, so the simplest, the simplest, easiest solution to accommodate my disability on the first request is to treat each other with respect, hear each other out, give people the answers they deserve, and act like you're being paid by taxpayer money and you work for the state and you serve the public, okay? So that's the first accommodation. The second accommodation I need is with the judge. The judge needs to accommodate the fact that I'm innocent until proven guilty, okay? She needs to talk to me like I'm innocent. She needs to talk in court like I'm innocent. When she refers to the case, she needs to refer as if I'm innocent. When the state speaks, that she needs to force the state to speak as if I am innocent, and they have the burden of proof to prove me guilty. The judge will not come in the courtroom and speak as if I am anything other than 100% innocent beyond reasonable doubt. So she's going to litigate the proceedings, proceed over the judicial proceedings under the assumption that I am innocent until proven guilty, 100% factually and legally innocent until proven guilty. The last hearing, she came in, sounded like the prosecutor, okay? And I'm telling you right now, this shit's going to go off the rails extremely quick if the judge pulls that with me, okay? When the judge speaks about me in reference to me, she will speak as if I am 100% innocent until proven guilty. She will not speak as if she's assuming I'm guilty and I need to prove that I'm innocent, okay? The last hearing was an abomination, okay? And that won't happen this hearing, okay? You would have thought she was the prosecutor when you listen to her talk. She's the judge. She needs to sit there and be quiet and let the parties present the information, and then she goes from there. She doesn't get to project her voice into the record as if she's already assumed that Lane Myers is guilty. She needs to state on the record at the beginning of the hearing today that Lane Myers is innocent until proven guilty beyond a reasonable doubt in a court of law, okay? That's how we're going to start the hearing today. That's my second accommodation. She's going to announce in open court on the record that Lane Myers is innocent until proven guilty, okay? So that's the second accommodation. The third accommodation is after we start the hearing and she announces into the record that Lane Myers is innocent until proven guilty, she's going to let Lane Myers talk for 10 minutes uninterrupted so that he can bring the court and the record, because it's not about the judge, it's about the record. The record. I'm stating these things for the record. This is my life. This is my court record. This is not the judge's courtroom, okay? The judge is just there to oversee things. This is my courtroom. This is the people's courtroom. This is the state of New Mexico versus Lane Myers. I will have 10 uninterrupted minutes at the beginning of this hearing to address the past 2 years, the deficiencies in some things, to state how I want to move forward, I need 10 minutes to talk to the record, not the judge, the record. There's things on the record that I need to correct on the record, okay? Just like Judge Ball needed to correct the record, Lane Myers needs to correct the record, okay? So the first 10 minutes after we introduce ourselves and say, hi, you're here and all that, I'm going to have 10 uninterrupted consecutive minutes to speak and make my point. I will then remain silent until it's my turn to talk again. If I do not receive the 10 uninterrupted minutes to speak at the beginning of the hearing is going to be an absolute mess, okay? Okay. Now this is the fourth accommodation, okay? The fourth accommodation is the judge is not going to cut people off from using the video links, okay? The link is on the website and it's open to the public. So right now we tested her earlier and she was blocking people from using the link, okay? I'm telling you right now, my fourth accommodation is on the website where it says public access. If one single person gets cut off from that, if there's one single person who wants to attend this hearing today and is not allowed to attend this hearing by using those links on the front page of the website, that's an ADA violation. Because my accommodation for my disability is the emotional support of my family and my friends and my ADA coordinators and my advocates being able to watch my hearings and know what's going on so they can provide me emotional support and guidance and help me control my disability in real time. So if you think you're going to have secret court and block all this off and all that, then I'm going to be coming to court disabled. Okay? If you want me to come to court abled and accommodated, okay, then anybody who wants to attend the hearing today at 1 o'clock by using one of the links on the website will be allowed to attend. If I get notification that after the hearing starts, that one single person who wishes to attend is not allowed to attend, the hearing is going to go off the rails immediately. My disability will be triggered and the judge will be in violation of the ADA. My disability accommodation is I live 12 hours away. This is video court. My family, my friends, my legal advocates, my social workers, my mental health professionals that I don't even have that I'm just making up to make it sound good, all that, right, will be watching. The FBI, the government, the police, prosecutors. I have a big fan club, okay? And I also have a big support team, okay? And so knowing that knowing that an FBI agent can log in and watch my hearing today, helps hold me accountable. It's my accommodation. If I know my mom is watching, then I am better able to control myself, okay? If I know my support staff is watching and they'll be able to give me feedback, then I'll be able to have a successful hearing. This is an ADA accommodation. Just like bringing my service dog, I'm bringing my service live stream, okay? I'm bringing my emotional support live stream so that I know that whatever happens in court today, the whole world is going to know what happened in court. We're not going to have no secret courts where no judges are trying to railroad me or act like I'm guilty until proven innocent. The whole world will be watching the hearing at 1 o'clock or my disability has not been accommodated. My fifth disability is I have Tourette's and sometimes I use swear words in the middle of my sentence, okay? I also have ADD. I have a short attention span. I have the ability to speak longer than I have the ability to listen, okay? So to accommodate my disability, now I realize it has to be a reasonable accommodation, okay? So as I said in the beginning, I need 10 uninterrupted minutes at the beginning to speak, to address all the things that that I have not been able to address in the past year or so, that I need to get on the record, and I need 10 minutes to talk to the record. It's not to talk to the prosecutor, it's not to talk to the judge. Then after that, once the hearing starts, this is the fifth accommodation. I might swear, okay? I just might. Get over it. I have ADD, ADHD, I have a short attention span. If the judge's going to sit there and bloviate, talking about how I'm guilty, or she is I will, my disability will be triggered. I will blurt out a profanity, and I will interrupt her, okay? If the judge conducts the hearing in a professional manner, the words coming out of her mouth are based in court procedure and legal precedent and rules of court administration and things of that nature, and I'm accommodated, the hearing will go very smooth. As long as the judge isn't triggering me by doing something unethical or misconduct or gaslighting or lying on the record or misspeaking on the record or manipulating the record or acting as if I'm anything other than completely innocent 100% until proven guilty, my disability will be triggered, my ADHD will kick in, my Tourette's will kick in, and I will be interrupting the judge, lacing her with profanity. Those are my accommodations for my hearing at 1 o'clock today. So make sure the judge is aware that this is ADA now. We're not playing, okay? I'm claiming the ADA early and often. And I'll go straight to a disability lawyer and put a lawsuit on her head if she can't make these reasonable accommodations based on my disability. You want documents? ADHD, look it up. I don't need to prove anything, but I can, so we can go there if you need to. And all you need to do is do some research and you'll realize that I'm going to interrupt the judge today because I have a disability if he goes off script. If the judge comes in there and sounds like a judge and is acting like I'm innocent and the state has the burden of proof and she lets me get 10 minutes to correct the record from all the things that my last lawyer's messed up, it'll be the smoothest hearing she ever has as long as the whole world can watch it take place. But I'm worried right now that this judge thinks she's in control. I'm worried that this judge thinks she actually can stop people from listening in on the hearing. She can actually stop a public hearing from being public. I'm worried based on what I've heard her say in open court on the record that she operates as a prosecutor because she had 21 years in California as a prosecutor. She came out firing like she was the prosecutor. The judge needs to sit there and shut up and let us work it out, okay? There's a time and a place for the judge to talk, and it's not for her to give her legal opinions from the bench, okay? Nobody gives a fuck what her opinion is until it matters, okay? Her opinion only matters when it matters. And right now, her opinion needs to be in the first, as soon as the hearing starts and she says, we're now being recording, she needs to state, for the record, Lane Jeffrey Myers, 10-15-82, is innocent of all crimes until proven guilty beyond a reasonable doubt in a court of law by a jury, okay? That will determine the rest of the hearing right there. And then those other accommodations will be met, and I'll behave, and I'll act professional, and my arguments will be legally cognizable. But if those aren't met, this is going to turn into a giant shit show for the whole world. I'm going straight to the chief judge. I'm getting her recused, moving it to another thing, putting a lawsuit on her head, and we can play those games. It's not a lawsuit for her decisions. It's a lawsuit for ADA accommodations. So you've been put on notice. Thousands, millions, hundreds of thousands of people are listening to this phone call right now around the world because this phone call is being broadcast live on the internet around the whole entire world in real time, just like my hearing's going to be today. Okay, Kim? So now the whole world has listened to me seek these ADA accommodations, all right? This phone call is recorded. It's on the internet. It's live, and people on 6 continents are listening. So if you twist my words, you know what time it is. If the judge doesn't accommodate me, she knows what time it is. The whole world knows what time it is. Lane Myers doesn't get railroaded. Lane Myers doesn't have judges talking down to him. Lane Myers doesn't have judges talking to him like he's guilty. Lane Myers will be accommodated. The truth, the innocent man, Lane Myers, will be able to come and speak his truth to defend his innocence that he doesn't even need to defend because the burden of proof is on them. So my next call is to the chief judge in district court and the court administrator. Everybody will be on notice about today's hearing prior to today's hearing. And it will be live streamed because it's a public hearing. And if you think you can hold me in contempt, that's a rabbit hole I can't wait to go down with you. My ADA accommodation is I need to live stream this hearing so my family, my ADA support, and everybody can make sure they can emotionally support me so that if I'm confused when the judge is saying something, they can send me a text saying, calm down. My wife's a lawyer also. She needs to be able to watch. The FBI needs to be able to watch. They all need to watch. Everybody needs to see what's going on in this courtroom today. And that's what's going to happen. Because it's on your website. It's a public link. It's public court. And it's going to be broadcast around the world. And that's my ADA accommodations. And you can get to work on them. You got till 1 o'clock. And I look forward to having my hearing and being accommodated and behaving and treating the judge with respect and being treated with respect.
Okay. Do you have a phone number that I can call you back at if I need to ask you any further questions?
520-771-2021. Thank you, Kim. Have a great day. I appreciate it.
You too. Yeah, sure. Take care.
Bye.
Okay, bye.
Early and often. Early and often. Early and often. That's when you let them know. You let them know early and often. Isn't that what they told me on the ADA? Early and often. Where's my ADA guy? Those are my ADA accommodations. They'll be accommodated and they'll met early and often. Early and often. Right?
In that vein, I'm asking please silence any electronic devices, including message alerts on your phones or computers while court is in session. If you must take an urgent call or have to respond to an email or some other message, I'd ask that you leave the Google Meet and come back when you're able to give your full attention to the proceeding. I have received no requests from any news media nor expressly granted permission to anyone, so therefore no one is authorized to broadcast, televise, photograph, including screenshots, or record in-person or remote judicial proceedings pursuant to New Mexico Rule 23-107, paragraph F. Any violation of this rule or any court rule may result in the imposition of sanctions by this court, including but not limited to removal from the court, including the Google Meet, fines levied, being held in contempt, and denial of a motion or relief requested in the hearing. All right, we are here in the matter of the state of New Mexico versus Myers, M33MR 2024-00017. I see the state is represented by Mr. Wahlquist, who appears remotely via Google Meet. Mr. Myers, are you there? Mr. Myers, *6 if you're with us, please. Mr. Wahlquist, have you had any contact with the defendant?
The defendant was on the hearing on Tuesday, Your Honor, when you announced today's date. He has been in contact with me. I'm sure he's on the line right now. I think he's just having a hard time unmuting. He's on a phone. He needs to press *6. Press *6. That will unmute you. Or if you're on video, just click the button for the microphone.
All right, we'll give him a few more minutes. I know that there are some technical difficulties with these online proceedings. All right, Mr. Myers, in the event that you might be having technical difficulty, you can also call into the meeting if the video is giving you enough trouble. Sometimes I think when you don't have good service or good Wi-Fi, it's going to cause problems. That number, if you have a pen or hopefully you're on the line, is 1-619-880-6524. And that access pin is 468-172-750#.
Your Honor, I like to call in by phone for audio. When I tried to do that number with that PIN number, it put me on hold until the host would let me in. So I don't know if that might be an issue as well. I have not heard that.
No, I'm in now. There were so many people trying to log in that it was doing exactly what the state just said. Hold on, please wait, please wait, please wait. And then I had to press *6 to unmute and all that.
Thank you. All right. Thank you, Mr. Myers.
Good afternoon, ma'am.
Good afternoon. All right. So, Mr. Myers, let me just state also that you appear remotely via Google Meet. I understand that you've requested an additional person to appear with you as a non-party participant. I'm going to ask that. Who is that person? Can they identify himself or herself?
Whoa, I'm confused, ma'am. Hold on, let's take a step back. What did you just say? Because I'm not familiar with anything you just said.
Okay. What I'm asking, you know what, let me start over, because if you just joined us, then you may have missed my introductory comment.
I absolutely did not hear anything before Kent Wahlquist was saying, when I heard, the first audio I heard was Kent Wahlquist saying, ma'am, I was trying to log in and it was giving me the PIN number or something.
Okay. All right. So I was mentioning that to everyone who's here, this is a public court proceeding. You're subject to the same rules as if you were sitting in court here with me. I expect that everyone, members of the public and parties, to exhibit the same level of respect and decorum of any courtroom. I'm asking that anybody silence their electronics, including message alerts on your computer or phone, while we're in session. And if you do need to take a call, this doesn't necessarily apply to you, Mr. Myers, because obviously you're a party here. But if any members of the public need to respond to an urgent call or message, then I ask that they leave the meet just like they would leave a courtroom and then return when they've finished their business. I am also mentioning that I received no request from news media and I have not expressly granted permission. Therefore, no one is authorized to broadcast, televise, photograph, including screenshots of the proceedings, or record in person or any remote judicial proceeding pursuant to Rule 23-107, paragraph F, as in Frank. Any violation of this rule or any court rule may result in the imposition of sanctions by the court, including but not limited to removal from the courtroom, including the virtual courtroom, fines levied, being held in contempt, and denial of a motion or relief requested in the hearing by any party. I stated that we are here in the matter of the state of New Mexico versus Myers, M33MR 2024-00017. I mentioned that Mr. Wahlquist appears on behalf of the state remotely via Google, and now I'm also able to state that you are also appearing remotely via Google Meet. So we're at the point now, Mr. Myers, where I was informed that—
a follow-up question to your second point that you addressed right there, ma'am. I'd like to address something in open court for the people that are listening, myself, as well as you and the state.
Okay, well, this is, you can address me and the state, but direct your comments to me.
No,
Go
no.
ahead.
What I'm saying is because I'm saying that you made mention of the whole audio broadcast, that kind of thing, and the
Mhm.
penalties, and made note of the Supreme Court order and all that.
Correct.
So my question is how would you stop somebody? I just want to make sure that this is a universal, like a rule that is unilaterally applied across all news media. Are you saying that even like a KQ, whatever, KOAT or something, if they wanted to click this link, if they wanted to join, go to the remote website link, access all that, and they're on there. If then like the local channel 5 or whatever wanted to then broadcast that live, you're saying they would need permission from the court?
That is correct. This is a judicial proceeding, just like if they had a camera in the courtroom. All right. So,
And you're
Mr.
saying
Myers,
that we can put those requests in where?
you can you can make that request to me or to the chief of the First Judicial District.
All right, I'd like to address something with you ahead of time. There's going to be people broadcasting this around the world. And so I'm just curious how you're going to enforce that in like Australia or something.
I'm not the enforcer. That's the police department. So, I'm just advising. I'm just
I'd love
advising.
to show you that. It's
Mr.
not
Myers,
recording, but
Ms.
it's
Myers,
possible that
okay, we're
will be
taking
a-
turns here. We're taking turns. So when I'm speaking, don't interrupt when you're speaking. I
My
won't
bad.
interrupt. Thank you.
Please
All
just
right.
like delete.
Okay. So I also need to identify, I'm told that you requested a non-party participant support person. I would ask that that person identify him or herself.
And I would respond to that by asking who told you that, because they're grossly incorrect.
Okay. All right. In that case, then there is no identified support person. Is that correct?
I'm not even, you're coming at me with, I have no idea. Are you sure that you're talking about Lane Myers?
Yes, I'm talking about Lane Myers. Did you have a designated support person?
Oh, you mean my ADA accommodations that you're not supposed to bring up in open court?
Do you have a support person?
What do you mean support?
I'm asking if you have someone here to support you, either emotionally or organizationally. That
Oh,
you have.
absolutely. I have. You just look up at the screen, and however many people are on the screen watching right now, they're all supporting me.
Okay, well, you have one. So who's that person? I'd ask that they identify themselves.
When you're saying you want one specific person to say that they are my specific person?
I just need one person in the event that I need their assistance to support you.
Oh, I see what you're saying. That's why I called ahead of time to make ADA accommodations with Kim Moore, and you were supposed to address these administratively and privately before the court hearing, and you never reached out to me because you guys blocked my number down at the court.
Okay, so who's your support person, Mr. Myers?
We can discuss this in private, ma'am.
Okay, then until I have the name of that person, then I'm not going to be able to communicate with them in the event that they need to assist you. All right. We are here originally because we continued the hearing from Tuesday on your motion to suppress. Your then counsel was going to provide supplemental authority for your argument. However, I understand counsel.
That was their argument.
Okay, and I understand counsel has withdrawn. Is it correct, Mr. Myers, that you wish to proceed pro se?
Yes, I'm going to get all my official notices of appearance, and the problem is I haven't even actually been served anything from the court or the lawyers saying that they've withdrawn, and the court was saying I couldn't file my motions until they officially withdrew. And so again, I've been calling the court for 2 days trying to ask the status. I looked it up on Case Lookup, that kind of thing. Hey, before I file these motions, I need to know that they've removed themselves. The court blocked me from calling. So, that's where we're at already. The first day that I've been representing myself, your court blocked me from lying. And I'm pretty sure you were on speakerphone and heard the whole conversation, but it's all good. It is what it is. And so moving forward, I'm the lawyer and I'm the party, and the state needs to serve me. The court needs to serve me. They have my information. I was previously the lawyer until I was preyed on by these other lawyers, but we'll deal with that with the Bar Association. And so I do want to state for the record that I believe it was the ineffective counsel claim, and I want the record to reflect that should this go to appeal, there will be an ineffective counsel claim based on the events between October 5th and yesterday.
All right, Mr. Myers, you don't need to show your hand regarding your issues on appeal. My understanding is then that you intend to represent yourself. Is that correct?
Absolutely. Do you want an official notice of appearance on the docket?
Well, we have to go through a whole colloquy here to make sure that you are able to do that. You understand you have a right
Able to do what?
to represent yourself.
Oh, I didn't need to do that last time.
I don't know what you're talking about last time.
Well, I was my lawyer for 5 months already.
Okay. Well, I have not
I filed
had,
motions dismissed. I filed 30-page motions dismissed citing case law that the Judge Madrid was about to dismiss the case. We came to the hearing and he was
So-
going to dismiss the charges, but he allowed the state to amend the charges.
so Mr. Myers, I don't know what you and Judge Madrid and your attorneys did before. Now that you're with me, I need to ask you a series of questions to make sure that you are in a position to represent yourself.
I'm also allowed to exercise the right to remain silent. I'm not trying to be difficult with you, Miss Taylor, but this is a learning. This is gonna, like, what I'm saying to say is you still haven't you got your notification about me possibly needing support, but I haven't hear you say that Lane Myers is innocent until proven guilty in a court of law beyond reasonable doubt.
Okay, we're past the point of arraignment, Mr. Myers.
But I haven't heard Catherine Taylor say it. I heard Judge Madrid say it.
Okay, do you want me to go over your rights?
Absolutely. That's my point. I wasn't even at the first hearing with you, and I want to start over like you with me, like we just started this case. Like it was like, okay, here we are. I don't need to be rearranged per se, but I would like you to put on the record with me as the counsel my rights and my, you know what I mean? Like the same things you want to read. Could you just please kind of address the arraignment rights and stuff first?
Okay, so we're not going to go through a rearraignment. You've been arraigned on the charges, and you were arraigned sometime in 2024?
Because they've been amended and I haven't been kept in the loop, ma'am. I'm not trying to be difficult. I literally had charges that I was the lawyer, and sometime while I had these other lawyers, the state did things, they did things. The lawyers will not turn over a single file to me. I'm completely in the dark from October 5th, 2023 till today. So what I'm saying is I don't know what they did. They don't tell me. So whatever took place, and I'm reading this response now from Kent Wahlquist, the charges seem to be amended. So was I rearranged? No. Okay. Because I can see they can, on the pleadings, I know the deal about amendments. Okay, cool. I'm not arguing that they can amend it or not. They amended it. Good deal. We're amended. So as we speak right now at this stand, is it trespassing B and the other two that were original?
All right, Mr. Myers, let's go over that. I'm going to go over your rights, then we're going to go over the charges, and then we'll decide what our next steps are going to be. The thing is, at this point, you don't have an attorney and you have not entered on the case. I need to ask you a series of questions to determine whether
Let's do that first. Yeah, let's do that first. Get me whatever you need to satisfy the requirements to make me the attorney of record. Let's do that first and then go over that other stuff.
Okay. Well, I'm going to arraign you first because that's typically how we do it. And then the attorney will enter on the case at a later time. So
yes,
we'll go through our colloquy in just a minute. I'm going to go over your rights now. I'm going to go over the charges, and then we'll take our next steps. Please listen carefully. You have the right.
File the appearance while you're talking.
You're going to what?
File the notice of appearance while you're talking.
Okay, but I need you to listen, not file things.
I'm talented and gifted.
Okay, congratulations. My point is, I need your full attention when I go over your rights.
Are you assuming that I can't listen to you and type a motion
I
about
need
my rights that I was born?
I need your full attention when I'm going over your rights. You requested me to go over your rights, so I'm going to go over those rights, but I want your attention while I'm doing that. Don't do any other.
I won't type.
Thank you. You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to know the charges filed against you, the maximum and any mandatory minimum penalties. I'll go over those with you in a minute. You have the right to reasonable conditions of release to secure your appearance at all future court proceedings. You have the right to see, hear, question, and cross-examine any witnesses who may testify. You have the right to call witnesses and present evidence on your own behalf. You have the right to an attorney now and at any stage of these proceedings. If you cannot afford an attorney, one will be provided for you. You are presumed innocent unless you are proven guilty beyond a reasonable doubt. Do you understand those rights, Mr. Myers?
Yes, ma'am, and I appreciate that. I just wanted to hear that in your court.
Of course. All right, let's go over the charges. You have been charged. Oops. You have been charged in count 1 with criminal trespass in violation of section 30-14-1, paragraph B. That is a misdemeanor. That penalty is up to 1 year in jail and up to a $1,000 fine. Count 2 alleges that you resisted, evaded, or obstructed an officer in performance of his duties contrary to section 30-22-1, paragraph D, as in David. That is also a misdemeanor. That is also a penalty of up to 1 year in jail and up to a $1,000 fine. Thirdly, you are charged with concealing identity in violation of section 30-22-3, a petty misdemeanor. That penalty is up to 182 days in jail and up to a $500 fine. Do you understand these charges and potential penalties, Mr. Myers?
Yes, ma'am. I just wanted the record to reflect my name is Lane Jeffrey Myers, and that is my birthday and all that. So I don't know how I'm concealing identity, but it is really me.
Okay, thank you. All right, so Mr. Myers, let's go. You already have entered a not guilty plea. We're going to proceed under that presumption. My understanding is you do want a jury trial in this case. Is that correct?
Absolutely.
Okay. All right. So that's kind of what brings us to where we are now. We originally had a scheduling order. We had a jury trial scheduled for February 13th. We're going to have to amend that scheduling order to accommodate what our next steps will be now that you don't have counsel. So
Yes, ma'am. If I could ask, I would say just reset those dates. I'd ask for the same courtesy of those dates. Just bump out a little bit. I mean, I'm a fast typer. My motions I don't wait to I'm not a deadline guy. I'm as fast as possible guy. So the deadline can be reasonable. They don't need to be extreme. I'm not a kick the can down the road, waste the court's time kind of lawyer. And so reasonably, if, my intention is to get my appearance in, make that official, then request some documents from the state again, get back, pick up where we were with that stuff. I'm going to request pretrial interviews on the amended charge specific to those. I already have what I need on the 2 original charges, so I'm going to need to re-interview those 2 specific to the amended subsection. And then I'm going to need to prepare my subpoenas, get those out. I'm going to file a couple dispositive motions that they're both basically going to be, updated versions of my previous dispositive motions. And then from there, we're going to, same thing, pre-trial, get ready, voir dire, all that, that whole thing. Basically, if you could reset me back to kind of where we were at, we're like originally on December 5th, you told them the schedule. And then today was like, we'll discuss the motions that have been filed. That's what I'm asking you to give, like make today the case management conference, give me a deadline to file motions that they can timely respond to, and then have this same type of hearing that would have taken place 2 days ago where you had time to be fully briefed, come to the meeting, give us a chance to, provide additional testimony to our motions, and then proceed from there to, like you said, the pre-trial. Basically, the stuff you were talking about on a couple of days ago about, if I decide this motion today, next we're going to have to deal with the jury because we don't want to talk about some of this in front of the jury and all that. So if you could keep me on that same timeline, that'd be great.
all right. So Mr. Myers, it's sounding to me like you're very familiar with the process, with the court process.
Very, very extremely familiar.
What is your background?
Do you really want me to say this in open court?
Well, I want to know what it's one of the questions that I need to ask you.
Oh, I see what you're saying.
Determining your pro se status. So it sounds to me like, yeah.
My background in legal, you're saying.
Right. No, I want to know. I want to know.
Sorry. There's a slight delay, so I'm trying not to talk at the same time as you, ma'am. I want to give it. So what I'm going to do is I'm going to let you talk, and there might be like a hesitation before I respond, just to be on the safe side.
Perfect. I appreciate that. So I'm going to ask you a series of questions kind of that go into a little bit more detail. About how old are you? You were born in 80 something?
Well, I'm not about a certain age. I'm exactly 42.
Okay. And what's your level of education?
Master's of legal studies.
Okay. And are you a native English speaker?
Yes.
Do you speak any other languages?
Yes.
All right. What was your first language, I should ask?
English.
Okay.
Legalese. Hey, ma'am, can I change it to legalese?
You can, it sounds to me like you are fluent in English.
And legalese.
Okay, good.
My second language was legalese. I wanted you to let me get that joke in. It's all good though. Go ahead.
All right. And it sounds like you have significant experience with the criminal justice system or the court system?
Not the criminal, but yes. I just went 16-0 over the last few months in these kangaroo courts down here in Arizona. Every single charge that I got, I have my own Westlaw. I have my own legal consulting business. I'm a paralegal. I don't want to talk about my wife because she doesn't help me.
Okay. Well, yeah, I'm just concerned about your status. So
I said that because there's people that are listening that know why I said that.
Do you have a paralegal certificate?
I have a college degree, but I don't have an active license in Arizona. I got it in Michigan, so I need to get their little certificate. You know what I mean? It's like having a professional license in Arizona. They have something called a licensed legal professional. It doesn't matter because this is all
But
hobby.
were you licensed as a paralegal in Michigan?
You're asking questions that I feel would prejudice me if I answer, so I feel like it's just like you're you know what I mean?
Well, I mean, they go to my assessment of
I mean,
whether,
I got my paralegal degree in prison. What do you want me to tell you? You want me to tell you that I've been to prison and prejudice you?
no, I want to know what your education is. So you have a paralegal certificate or you completed the course studies for
I have a
paralegal?
college degree, ma'am,
But
from the University of Ohio.
did you complete the paralegal studies?
Yes, in 2001 at the Toledo Community College, and then I went to the Ohio University and got the stupid certificate, and then I got out of prison and I tried to get a job, and they said we don't hire felons. Cool certificates. So I said, you know what? So I wasted on my. But anyways, it comes in handy for things like this.
Okay. All right. So, and I am satisfied, I will also mention for the state, I'm satisfied that Mr. Myers has clearly and unequivocally asserted his intention to proceed pro se. I do find that it is timely. It's prior to our trial date that was set. So now, Mr. Myers, I want to, my questions are pertaining to whether you are knowingly and intelligently relinquishing your right to counsel and the benefits of legal counsel. So you had two attorneys that you had hired that were.
I didn't hire them. First of all, ma'am, I want to correct the record. I did not hire them. We'll get into that. Me and you can maybe, I don't know if that's ex parte, but like, please do not state on this record that I hired them. I let the record reflect. I did not hire them, but go ahead now.
And just so you're aware, also, Mr. Myers, we are not a court of record in magistrate court. So I understand the term on the record is a term of art.
You told me you were recording.
What's that?
On the other day, I heard at the beginning when you said the record, we're recording. Okay, yes, we're recording. All right, ready, set. Okay, now the hearing's going. I was under the, that threw me off. I agree with you. I did know that. The reason that I brought up the record was because you brought it up the other day, and I was like, whoa, is this magistrate court suddenly a court of record? Because Rio Arriba wasn't.
Right. No, none of the magistrates in New Mexico are a court of record.
And that's why we want to live stream and record, because we don't let anything happen in the silence of the darkness of courts.
We don't live stream and broadcast from courts. So
No, we get permission.
it is a confusing, I understand. The proceeding is recorded, but it is not a legal record, if that makes sense.
So okay. Now, no, I'm glad. I don't want to get into the area of legal advice from the bench or not, but I do appreciate that. We're like, okay, cool. So when you say specifically recording, you're talking about basically making a digital audio recording for the court's records, not a digital recording that could then be transcribed by a court reporter later and linked to and stuff like that.
That is my understanding, correct.
Thank you, ma'am.
All right. So, Mr. Myers, I'm going to go over a couple of factors that have been outlined in precedent that talks about how to make sure that you are knowingly and intelligently waiving your right to counsel. It sounds like you are very well versed in the legal process, and you understand that you're going to be going, if you represent yourself, you're going to be going up against the prosecution, and the prosecutor is a very experienced attorney. You understand that?
Ma'am, are you telling me this because there's something on a piece of paper says that? Because I feel like right now you're bordering in a gray area that you shouldn't border into. First of all, you were a prosecutor for 21 years. Okay. I don't need you to prosecute me from the bench. Second of all, I'm very aware of who I'm going against. I'm going against an incompetent moron, Kent Wahlquist, okay? These filings look like a high school kid wrote them. I'm extremely
Mr. Myers, we're not going to insult the other party. He's not going to insult you. You're not going to insult him, and neither of you will insult
I feel like you're gaslighting and being you're literally questioning my intelligence, okay? I might know more about New Mexico law than you, ma'am.
And you very well may, Mr. Myers, but the point is, I am required under the law to inquire into this line of questioning.
You sound like my mom asking me if I'm sure I want to do this.
Okay, be that as it may, my questions are important to establish that you are knowingly and intelligently waiving your right to counsel.
You know what's weird is I did 3 days in jail and I filed a notice of appearance the next day. I've never had to hear this. I probably filed 45 motions in this case, and I've never been asked these questions.
Okay. All right.
So I'm just curious why Judge Madrid didn't do that.
You-
But I want to give you the benefit of the doubt, ma'am. I do want to give you the benefit of the doubt, and I want to acknowledge it for you, for everybody. I can be difficult, ma'am, but I do respect you, and the reason I'm going through this little back and forth with you is because it is your courtroom, and it's your courtroom to run, and every judge runs their courtroom a little differently, and some of them go by, follow the procedures, and I believe you're ethical, and I'm not accusing, and I feel like if you're saying, the reason I'm acting surprised about some of this is now my light bulb just went off, and I'm going to stop interrupting you, and it tells me that I was supposed to have this happen to me before, but maybe it didn't. So it's not a you problem. It was the last judge's problem, and the light bulb just went off, ma'am. So go ahead with your questions. I'll give you the due respect to answer them in kind, but it's just new to me, having already been through this, wondering why you're doing this when it wasn't before. But now deductive reasoning tells me that it was the other judge, not you.
Okay. So the reason I'm doing this, Mr. Myers, is because you had counsel and they've withdrawn, and you've indicated that you want to proceed pro se. So now that has triggered some requirements on my end to establish that you are doing this, like I said, knowingly and intelligently. Those are the magic words. And there's a series of questions that are outlined in precedential cases that I have to inquire to establish that you are, in fact, understanding what you're giving up and understanding what you're going to be responsible for if you represent yourself. So,
no problem, man. Ma'am, you want me to press play on the phone call that after your hearing last time that they called and threatened me? You want to hear the call?
We're not doing any recordings or calls.
Then you'll know well, you said you wanted to know that I was doing it knowingly, intelligently. Well, how about you listen to the call that my lawyers called and said to me after that last hearing, and you can make your judgment why I'm making my judgment.
Okay, because that's multiple levels of hearsay, Mr. Myers, and we're not at the point. I'm not getting involved in your issues.
That's
with
the
your
bar thing. The bar thing, we'll leave it out of your courtroom.
Right. So those are all things that you would need to take up with the state bar. They've withdrawn from your case. That's between you and those gentlemen.
Do you have any authority left over them still to order them to turn over the previous files in this case? Because I have nothing, and they're refusing to give it to me, and they're passing it out to news reporters. But they won't even give me my own files in my own case. They're passing out attorney-client emails to the public.
Okay. Those are all state bar issues. They've withdrawn from your case. They are not.
So you can't order them to turn me over the records throughout the back part of the case?
Correct. They are not in front of me. All right.
I'll let it go.
All right. So I do believe that you've clearly and unequivocally asserted your intention. You've done this in a timely manner. It's not in the middle of trial. So I just need to establish now that you are intending to relinquish your rights to counsel. So specifically, and for the state's information and for Mr. Myers' information, I am following the guidelines set out in State versus Stallings at 2020 NMSC 019. If you go to paragraphs 15, 16, and 17, the Supreme Court has...
Westlaw or what? I got Westlaw up in front of me.
Okay.
Where do you want me to go?
Do you need that citation again?
Yeah, I got Westlaw right now. Go ahead, tap it out.
Okay, ready?
Yep.
2020 NMSC 019. November, Mike, Sierra.
Yep, New Mexico Supreme Court.
You got it.
I do this for a living, ma'am. Go ahead. Now, Stallings, State for Stallings.
Correct. State v. Stallings.
All right, what's up?
All right. I want to go over with you exactly. We went over the charges earlier. We went over your rights, but I want to go over specifically the significance of the penalties so that you understand really what you could be facing. All right. We talked about the first two counts are misdemeanors. They carry penalties of up to 364 days in jail and up to $1,000 fines. And the third count is 182 days in jail up to a $500 fine. I want you to understand that the maximum penalty, if those sentences are run consecutively, Mr. Myers, you could be looking at 2.5 years in jail and $2,500 in fines. Do you understand that?
Ma'am, you're lying to the whole world. First of all, I have no criminal record. You can't get the max on the first sentencing. I don't meet the guidelines. Recidivism is less likely. My sentencing score is very low. You're gaslighting me, and if you're doing it because you're required to, that's one thing. but you're definitely not scaring me because there's a better chance of me growing wings and taking flight than being found guilty in this case.
Okay, but regardless, you never know what a jury's going to do.
I'm not going to jail, ma'am, and you're not going to send me to jail because it's against your right to send me to jail because I don't qualify for jail even if I was convicted. So I know everything you know.
I am advising you that you could be looking at significant jail time and significant financial penalty if you were convicted and sentenced consecutively in this case. Do you understand that?
And the judge that did that would also be facing misconduct.
Okay, but do you understand the penalties?
No, it's not okay. You're threatening me with the max when I get the minimum.
Okay, I'm just telling you the maximum penalty.
You're not telling me anything. You're gaslighting me. You're trying to scare me that I might get 2.5 years. I'm not getting 1 hour in jail, okay? Let alone 1 year, 2 years, 2.5 years. This case is going to be dismissed by the state and quickly.
Okay, but let's go back to exactly what is on the books. The charges that you are charged with, the penalties that are on the statute.
Unlawfully.
Okay, the ones that the statutes you are charged with, those are the penalties that are part of those statutes. And I'm telling you.
If I was convicted.
Correct. If you are
Right.
convicted and you were to be sentenced consecutively, this is the worst possible outcome. Do you understand that?
So you're saying hypothetically?
Right. I'm not saying it's going to happen. I just need to make sure that you understand it could happen.
Absolutely. Hypothetically, somebody who has these charges, who has a long history of criminal offenses in the state of New Mexico and multiple this and multiple that, and has bond this issues and done this and has assaults and domestic violences and charges and violence and this and that, and it's their 20th charge. Yeah, I could see. New Mexico doesn't even put attempted murderers in jail, okay? I get it, though, hypothetically. Yeah, you could consecutive all that, but I also know that you can't run them consecutive, blah, blah, blah. I also know a lot more, but I don't want to turn this into trial right now.
Right. Okay. All right. So then the next thing I want to discuss with you is the procedure. When we're in a trial and we've got a jury in the box, do you understand and are you going to be able to comply with the normal courtroom procedure? That means not talking out of turn, not interrupting counsel, not interrupting witnesses. Do you understand that?
It's my legal obligation by representing myself, correct?
Right. You have to comply with the normal courtroom procedure.
I'm aware of my legal obligations, ma'am.
All right. How are you with the evidence code?
How am I? Oh, yeah, I forgot. These are all questions you have to ask. I'm very good.
All right. And you understand the appropriateness of making objections?
Absolutely. Oops, I almost accidentally, never mind. Go ahead. Yeah. Hey, if there's one thing I'm familiar with, it's objections. And I like that you're on your little profile, how you, that's good. I'm glad we're on the same page there so that you're going to understand my objections, unlike Joe Madrid.
Okay. But do you also understand that I will not take speaking objections? You must simply object and state the grounds.
We're talking about, I forgot we have to do this. All right. So yeah, for sure. I agree, ma'am. I agree. I forgot that we're talking about this in the hypothetical were it to happen sense versus this is about to happen.
Right. Mr. Meyer, just so we're clear, I'm just trying to assess that you understand what's going to be required of you if you proceed pro se.
I understand what you're saying, but I'm also a completely innocent man. So I'm working through the process of listening to a judge talk to me about court procedures, knowing that I'm 100% innocent and the whole world knows that, except I guess the only two people that don't yet, you and the prosecutor. But we'll make sure you know, and then the prosecutors have known for 2 years that I'm innocent, but we're going to make sure Judge Taylor knows in timely couple dispositive motions, and I feel like this conversation will all be hindsight.
As far as I am concerned, you are innocent. The state hasn't brought proof, so we are proceeding with the understanding that you are innocent until the state proves your guilt beyond a reasonable doubt. But if that goes to a trial, I just need to make sure that you understand what is going to be expected of you representing yourself. Without an attorney.
I've represented myself at multiple trials, and I've never lost the trials pro se. I've represented myself in multiple jury trials, multiple bench trials, over multiple days, federal court. I have federal court cases going right now, federal trials, 6th Circuit Court of Appeals, high-level circuit court. What do you want to do here? I've appeared in court.
I'm going to interrupt you, Mr. Myers, because remember, we went over this. Everything you say could be used against you in court. The prosecution is on the line. There are other witnesses to this proceeding, so I'm going
to... No, that's the point, ma'am. The point
But-
is to say
but
things
we're
that
not-
they
we're
that
not
I
in-
want them to try to use
We're
against me.
not going to interrupt each other, remember? So let me finish speaking. My
Slight
point
delay,
is,
sorry.
that's okay. I want you to focus on just this case and just this proceeding, okay? So let's not
You're,
worry
you're
about,
asking me, I agree, but you're asking me what is my experience with the jury and stuff, and I'm telling you, I mean, and the jury, I get it. You're saying, I understand. Have I went and read every single court decorum rule of Judge Taylor's courtroom yet? No, ma'am. I've just been on this case. I've been working the dispositive sides of it first, but I can assure you, man, by the time trial comes, me and you will be 100% lockstep, rock. It's your courtroom. The last place that I'm going to do anything to prejudice myself or look like a dumbass is in front of the jury.
okay. All right, you understand that you're going to be bound by those same rules of evidence and criminal procedure.
Yes, ma'am.
Okay. All right. Mr. Wahlquist, any comment?
On his, the colloquy for pro se, no, Your Honor.
All right, thank you. All right, do you have anything else you want to, and again, Mr. Myers, I'm asking specifically to lay sufficient groundwork for you to proceed pro se. I am satisfied based on the questions that you've answered, based on your background, the information that you've shared with me. My next question has to do with, are you on any sort of medication that could interfere with your ability to represent yourself?
Hell no.
Okay. And you understand that by trying to represent yourself,
Not trying, ma'am. Not trying.
well, I mean, you're going to be both the accused and counsel. And those can be very,
It's a tough emotional bridge to get.
okay, it's kind of a contradictions in some way, right? You've got to think clearly in terms of strategy and law, but you also
I
have
feel
a
like
lot
you're
of-
giving me legal advice, ma'am. I feel like you're giving me legal advice that I don't need.
Okay, and that's another thing that we should talk about. I am not able to guide you or give you advice from the bench. Do you understand that?
And that's why I'm questioning why you're doing it now. You're not my mom.
No, I'm not. But I'm just saying that as the judge, I have to run the courtroom just like you've talked about. And we have to keep it civil. We have to keep it procedurally correct and legally correct. And my
I'm
question,
asking to be able to do the thing other than occasionally accidentally interrupting you right here because I can't see when your mouth stops moving and then like the delay.
Mhm.
Other than the occasional unintended interruption right now, when I am appearing before you or in court or anything in your presence, when I'm saying Lane Myers wants to represent himself, I'm saying Lane Myers wants to be held to the same model rules of professional conduct, judicial. Yeah, I'm coming in there like I've got 20 years at the bar. Okay. And I want to be held. I want the pressure. I want the expectations. I want to be held to the highest standard of law.
okay. All right. Then
I'm going to
Mr.
do that
Myers,
to everybody else in this case.
right. And what I'm gonna need from you, and we'll have to figure out how we're gonna do this, is I'm going to need a written waiver of counsel. So
Yeah,
that's going
I'll type
to.
it out. You want it notarized and signed or what? You want it notarized, affidavit? What do you want?
No, it just needs to be signed and dated, and then you can submit it, and we'll figure out a way for you to submit your filings. You don't have access
No,
to
I
the.
got LM. So what do you mean figure it out? They told me I could use LALM-GRP or LAM filing just because in Madrid's court, I was filing motions just fine. It was almost the same thing before, but yours is like LALM filings -GRP or something.
Right.
That is where they told me I can file.
Okay. All right. Just so we're clear, because I thought there was some confusion with the file and serve. You don't have access to that, is what I understand. Is that correct?
Access to what?
You don't have access to file and serve. Your filings are going to come through the.
Are you talking about like, is that like the attorney, is that like e-filing for the court or for the bar or for the lawyers?
It's the e-filing that lawyers are required to use.
Well, if you got to be a bar member, I don't have it, but if I can sign up for it, I will. I'm an e-filer in federal courts, state courts, all over the country.
Okay. No, so you have to have a bar number. Okay. So you're going to
Cool.
file. You're
That's
going
fine with the LALM-GRP, all that. That's anything, notice of appearance, the waiver, anything, motion, that my communication certificate to service, I had intended to send all to there.
Yeah.
and then watch the docket on NM case lookup.
Okay, then you should be all set. So what we'll do is we'll have this sent to you. The waiver of counsel is going to be sent to you. And then you are going to need to sign it and date it and return it to the court through, you can do that through the filing email.
Electronically, right? When you say, can we establish a baseline here, ma'am, that we communicate electronically? I don't mean, I do have your personal, but I would never do that unless you request, because I'm not going ex parte off the wire here. But what I'm saying is like, unless you need some further like I won't use your personal email that you said the other day unless it's for the same reasons you told them to use it. You know what I'm saying? And so that shouldn't be an issue here, because I'll be fully briefed ahead of time and we won't need timelines to fucking argue our own motions. But anyways,
so that's another thing that we need to address, the swearing. It cannot happen in court. I realize that this is different since we're on Google Meet. There cannot be swearing.
All right. What's your I don't want to be petty right now. I don't want to be petty with you, because I do want to ultimately defer to your respect, and it's your courtroom, and I don't want to have what do you like? Are you talking about, every permutation of like shit? I mean, I don't want to like, you know what I'm saying? Is it like,
okay, I think we're all adults. We don't speak like that in formal settings, so I don't want to hear any swears. Okay, we're not taking the Lord's name in vain.
I do speak like that in formal settings, but I get what you're saying. You don't want that in your formal setting. It's your house, man. It's your house. It's your house. It's your rules. Right. I don't go to other people's houses and tell them how to run their house.
Right. Think of it like that. You wouldn't go to church and speak like that. So I don't want you to speak like that in public, in my public courtroom.
Ooh, don't separate church and state, man. Separate church and state, but go ahead.
Okay. All right. So we're going to be sending you our waiver of counsel that,
electronically.
Yes.
Thank you.
We'll be communicating through the LALM filings-GRP, and you have that
Please
address.
Electronically serve me too, though. Don't wait me 4, 5, 6 days. Like the problem that I'm dealing with right now is that, they'll file something, I'll get it 6 days later in the mail. I could have already filed a response by then.
Well, I mean, those are the old fashioned ways, Mr. Myers. There's the mailbox rule and all that stuff. So, but yes, we're going to proceed with the electronic filings. You'll receive.
They can do both if it's required. If it's statutorily required to like hit the mailbox, that's fine too. Court, you guys got to send out notices to court to make sure that I'm 100% lockstep with that. I was just wondering if we could get at least the courtesy of when the state files a motion, they're required to serve me, but Kent doesn't like. I'm not. We'll get into that. Kent has a fresh start with me also, and so. We're
following all statutes and procedures. So whatever the way the clerk is mandated to process is how she's going to process them. But we are going to send you the waiver of counsel. Once I have that signed waiver returned, you will.
Right now, as we speak, I'll sign or like future.
No, not right as we speak. I'm in the
Okay.
court. So I'm saying we're going to be sending that to you. Once we get that signed waiver back, then we can proceed with setting.
Then I can start filing motions and stuff.
Exactly. And
Perfect.
You're aware of the service.
Do you want an actual notice of appearance too, like a typed out? Because there was already one in there. I don't know if once you get counsel that wipes that one out, but originally I did file one. That's what was so confusing about all your questions. But I get the sense of why I feel like I'm in the right place. We're gonna get the book now.
Okay. So yes, I am going to treat you as you are pro se, assuming that I have this waiver of counsel back in a timely manner. So given the fact that you are competent and you have knowingly and intelligently waived your right to counsel and are prepared to proceed pro se, let's move forward with some scheduling dates so that we can move this along. You indicated, Mr. Myers, that you intend to file some motions. What kinds of motions are you contemplating?
Well, first, thank you for that. I'm going to establish something right now. Because I can verbally motion right now too, and intent here to be served verbally.
No, I'm not taking any oral motion.
No. Not my verbal motions. I want to be, I wasn't moving the court. I was clarifying something. What is the status? This is something I wanted to address. What is the status of the previous? Do you want me to file a motion to strike their previous motions?
No. If you want to proceed on those documents, we can.
No, I don't want those anywhere near my name.
Okay, so those are moot. They've withdrawn.
Thank you. That's what I wanted to know. Did you want me to file something to make them? I want them procedurally moot.
No, I'm not. today was our date for the hearing on the motion to suppress filed by.
Right. No.
So
And that's
we're
why, and I interrupted you the other day and you muted me and I was going to fire him right there, but you muted me. And I was going to tell you, don't even, you're literally offering to read documents over dinner. If there's one thing I can guarantee you, ma'am, you won't be reading documents filed by me over dinner ever again. Okay. And that I apologize for that first and foremost. We weren't prepared that day, but Lane Myers will be prepared. And so you won't be reading documents at dinner so we can have a meeting in 2 days that we could have had 2 days ago.
All right. So what are you do you have an idea now? You don't have to, if you don't know, that's fine, but do you have an
Oh, no,
idea?
I do.
Okay.
Yeah, that's why I addressed that first to see if I was going to need to file some motions to withdraw or strike, whatever, make them moot. So if we're starting from the point of fresh start, moot, I'm the counsel, you're going to get dispositive, dismiss and suppress. I'm going to give you some subpoenas. You're going to get, Kent and I'll exchange all properly disclosure. I'm going to get all my notices and disclosures and all that stuff updated with Kent to pick up where we were, see where they were at. You know what I mean? Come to the conclusion that this is my current trial disclosure. This is my current witness list. Get my subpoenas in, you know, that kind of thing, along with 2 dispositive motions, a motion to dismiss and suppress.
Okay. You're going to file those simultaneously?
Yep. Just like last time.
Okay.
And I'd request an evidentiary hearing on them if you needed it. Just kind of like the hearing yesterday or whatever, or days ago.
How much time? Well, that's going to depend if there's questions of fact or questions of law. So
No. There's no question of either, man, but we'll get to that.
All right. So tell me how much time you think you'll need to prepare those motions.
From today?
Correct.
Are you going to then factor in their, do I need to factor in their response or just my time to file?
No, just your time to file.
2 weeks.
All right. Then I'm going to set that motions from either party be filed within 2 weeks of today. So that puts us out to February 13th. So that was our trial date. All right. So I want any motions filed from either party by February 13th. And then obviously any response will be according to procedure. Discovery. What outstanding discovery is there, or is there any outstanding discovery? Where are we on
that might be a question. Me and Kent's gonna have to learn how to dial my number or use my email again, but he's gonna have to tell me where they're at because my own lawyers aren't telling me. So either Kent's gonna get the full, we're starting over, or we're gonna get some professional courtesy and some communications of this, because my own lawyers aren't telling me. So I'm gonna have to ask Kent, and you know, me and Kent aren't necessarily the best of friends here, and so it's you know what I mean? I don't know, and I'd love to give you a great answer right now because I believe in giving you definitive answers. However, in this sense, I'm completely flying. It's like I just landed on the moon, you know, from the moon into your courtroom to pick up where this happened. I have a lot of discovery. A lot of it's relevant to the charge that was amended. I'm going to need to get some new discovery pursuant to the amended count. And then from there, I still have my discovery on the original 2 that weren't amended. Like I said, the discovery, I'm just going to need a short interview with the 2 again for just pursuant to B, the C to B change. And then pretty much that is one thing I will say. They did turn over a lot of discovery. So I personally had it up front, and I don't anticipate them ever pulling out anything else because that would be like fake evidence. It had to have been created by AI.
So Mr. Wahlquist, this case looks like it's been going for quite some time. Are you aware of any additional discovery that has come to your attention since your original disclosure?
Not anything that's come to our office, but I know that while the other attorneys were on the case during the civil process of having the case reassigned away from Judge Joe Madrid, that there were several IPR requests done by the attorneys of record. I have no idea what they received.
All right. Well,
and neither do I, ma'am. That's news to me.
All right. Well, the state's not responsible for what they have. The state is only responsible for what they have access to, not your prior attorneys. So as far as
I know. They're required to turn over anything in their possession or the police. I know the deal.
Do we have witness interviews? Were those completed prior?
Then he amended the charges.
Okay, hold on. Mr. Wahlquist?
I filed a certificate of compliance because we did complete 2 pretrial interviews. I believe what Mr. Myers is saying is he wants to re-interview them after the variance under the New Mexico rules. I would ask for a motion on that as well.
All right. Mr. Myers, because that amendment was filed under the variance rule, you would not be entitled to re-interview those witnesses as a matter of course, but if you want to include that in one of your motions, we can consider the necessity whether or not that's going to be mandated to redo those interviews with how many witnesses?
Two.
Two? Okay.
I need an hour with each of them, that's all.
Okay, so I'm going to need to hear that by motion. It sounds like the state
worries.
had completed those and certified that they had been completed. So if we're going to ask those witnesses to resubmit, I'm going to need to have that briefed. All right, and disclosures, where are we on the disclosures, Mr. Wahlquist?
I had worked with Mr. Myers. I'm going through my notes now, but I believe we had emailed multiple times the discovery. So if he's missing anything, I would love for that to be listed specifically in a motion so that I can make sure that he gets what he believes he is missing. Or I will respond.
Did you turn over anything to them after I was not the lawyer?
No, Mr. Myers, we don't talk to counsel. If you guys take your conversations offline.
Oh, I thought he was asking me that. I thought he was literally asking me that.
No, he's just stating it. So these are things that you guys can work out offline. I am going to set a witness list deadline for each party. It shouldn't have changed too much, I imagine. So, all right.
Did my previous lawyer submit a witness list?
Let's take a look.
Because when you asked them in open court, I believe they said no, they don't have plan on calling any, and that's about when I jumped through the phone.
Well, no, they were talking. I was talking about at our suppression hearing if they had any witnesses to testify at the suppression hearing. We weren't talking about trial. I'm talking now about our scheduling order, and I'm going to require that the state disclose to the defense its witness list. That will include names, address, and telephone numbers to contact witnesses. I imagine that's pretty, you can turn that around pretty quickly, Mr. Wahlquist.
I believe it's all actually done, but I'll do it again just to make sure.
That state deadline.
I agree to do the same.
Okay, those deadlines for both parties. I want both of you to exchange your witness lists no later than February 7th.
Thank you, ma'am.
And then you said that you've turned over any exhibits. Do you know what exhibits you intend to use, Mr. Wahlquist, if in the event it proceeds to trial?
If I said exhibits, Your Honor, I apologize. I do not remember saying exhibits. And no, I have not disclosed what exhibits I would use. That's typically not required under any New Mexico rule that I'm aware of.
All right. Then I'm going to, let's go ahead and pick a jury trial date, and then we'll move backwards from there, because I am going to require that both parties disclose their exhibits prior to me bringing a bunch of jurors in here.
Thank you.
If we're going to have any arguments, I want those settled before I make people take off work. All right.
Thank you for that, ma'am.
All right, Mr. Myers, I need you to just wait until I address you. Please keep your comments to yourself. All right, where are we looking for a jury trial? Mr. Wahlquist, why don't you tell me your availability first?
Your Honor, I'm in trial the first week of March.
What about that following week, starting March 10th? How does that look?
I'm the on-call attorney that week, so I would prefer not to do the trial that week. But if you set it that week, I will be there.
All right, I'm out the week of the 17th. How about the week of the 24th of March?
That's fine with the state.
All right.
Are you asking Mr. Myers also?
Yep, I'm going to you next, Mr. Myers. What's your schedule look like? Let's start the week of March 24th. How's that looking for you for trial? This is our jury trial date.
Yes, ma'am. This is in the city of Los Alamos by the plant or the lab and all that, right?
That is correct, in Los Alamos
All
County.
right, I got to get with some friends there to see if I'll be able to stay at their house. Some local mountain bikers. I'm a professional mountain biker. There's some famous mountain bikers that live there. You might know them, Sid and Mackey. But so we'll come. I'm going to touch base with them and see if I can park, because I have like a converted van. So my intention would be to save money on hotels and camp type thing. But if not, I'll get a hotel. So anytime after that, it should be starting to warm up. So I'm cool with that as the minimum. Or if you guys need more, that's on you two.
You're okay with sometime that week of March 24th? I don't know how much warmer it's going to be, but you have the ability.
Oh, well, you don't need to. The court definitely doesn't need to accommodate that. I mean, that I was just saying that, like, I do, plan to, mountain bike and stuff like that. But that's doesn't take precedent over you setting your deadlines. Like, your deadlines don't revolve around my hobbies.
Well, I mean, if you're telling me that you're planning to camp when you're here, all right.
It's just because I'm gonna have to bring my dogs, and I have a camping van and all my bikes and that kind of thing. So it's like, yeah, if there's, if it's snowed in, then probably the forest roads are probably gonna be closed. But like I said, I'll get a hotel, Airbnb, whatever.
All right. Then also another issue we need to address before we set anything in stone is we're gonna need to have a time waiver. Right now, time runs for trial March 4th. So if you're willing to
trial stuff,
yeah, your speedy trial right. So if you're willing to waive that right, we can push it out a couple weeks. If you are not, then we're going to need to keep our original trial dates. How do you want to proceed?
Yeah, I'll waive that. No, I want to waive that because I need to get up this. I would be prejudicing myself. If you're telling me my speedy trial date's going to become sometime from February 13th to late March, early April, yeah. If you're telling me it's going to become December of 2026, no.
Okay. How much time do you want to waive? Right now, your speedy trial rights expire March 4th. Do you want to add 30 days or 60 days to that rule date?
Well, have you two agreed that the 24th is, kosher?
I mean, we
starting
can
somewhere around there. However many days we need to get from there to cover your little availability there.
Right. So I'm looking at, if you were to waive 30 days, that means if we commence trial prior to April 3rd, that week of the 24th. Okay. All right. Then I'm going to also.
Yeah, I agree to that officially.
Okay. I will make a note that you have verbally agreed to waive time or add 30 days to the rule date. That will make our new rule date April 4th of 2025. So let's go back to the week of March 24th. That is a Monday. Given the fact that Mr. Myers needs to travel out of state to come in person, I'm going to stack everything up that week. So let's set the trial date. How many days are we anticipating? Mr. Wahlquist, what's your estimate as to time?
Your Honor, the state only has 2 witnesses.
All right, Mr. Myers, what's your estimate as to time to present your case in chief?
Well, if we proceed to trial, I believe 6 witnesses.
And approximately how much time would it would
2 days? We should really get
2 days. 2 days to accommodate all your witnesses?
I mean, well, when I say I have them, that means they're overlapping though with the state. 2 of those overlap, you know what I mean? And so.
Oh, okay. No, just so factor in. So Mr. Wahlquist has indicated the state is calling 2 witnesses. He's estimating.
I would probably be calling where I gave it to him yesterday. Let's see, the Forest Service officers, 2 of those. All right, so 3, the cop. Let's see, 1, 2, 3, 4, my wife, 5.
Okay, and of those
5 that are not the 2 they're calling.
That are not who the state has?
Yes, I have 5 witnesses that are the state, that are different than the state.
All right, so we're anticipating the possibility of 7 witnesses. I'm going to set aside 2 days for this trial, including jury selection. So I'm going to set trial to begin Thursday, March 27th at 9 a.m. And that will include jury selection. All right, in that case, then I'm going to set pretrial conference for March 25. That's Tuesday. That's also going to accommodate any 403 motions, any exhibits, jury instructions. We're going to hammer that all out on March 25th on Tuesday. And that'll give both parties a day to prepare for the trial beginning Thursday. All right.
What is the day of the week of that?
Which one?
The one you just said.
For pretrial conference and hearings, we're going to set that for Tuesday, March 25.
And then Tuesday, then Wednesday, then Thursday, we have trial.
Right, Wednesday will be
That's
your
perfect. That means I
Wednesday.
can come there on the weekend before there. I can travel there on the weekend. Yes, that's perfect.
Exactly. Okay. All right. So we'll have a pretrial conference set for March 25th at what time? Should we just start early in the event that we have a number of issues?
I deferred to you two because you have professional obligations beyond this case. So I'm an early person, but you know, you have professional obligations I don't have.
Mr. Wahlquist, what's your schedule look like on the Tuesday, the 25th? What time do you think you could get up here?
I can be there by 9.
All right. We'll set for pretrial conference, exhibits and jury instructions, beginning at 9 o'clock on the 25th. All right.
Thank you.
Okay, once I get those motions and any responses, we'll go ahead and set a motions hearing. We can conduct those remotely. If those motions are going to be filed by the 7th, you'll have 10 days to respond. All right, that'll give us plenty of time in the event that we need to set any hearings for motions. Are there any other items scheduling wise, Mr. Wahlquist?
Your Honor, I think it would be useful to go ahead and get a motions hearing now. If I understood Mr. Myers, they're dispositive motions, which would cause all of the hearings you just set up that last week of March to go away. So I would like to give the date now.
All right, Mr. Myers, any comment?
As far as he's saying he wants one by, when I said I wanted you to set one, you said you got the discretion to decide that. Now he's saying it's by rule.
No, he's asking me to set one.
And when I asked you, you said that you would decide that once you saw the motions, and now he's saying he wants it ahead of time. So I mean, my position is I wanted one ahead of time also, but you said that you would want to wait to see if you needed one.
Right, but now it's sounding like that both of you are contemplating potential motions, and we may as well get one on the docket so that I can set aside sufficient time. These would be remote, so you don't have to worry about traveling. I just don't know the nature of the motions or the time estimate. So I'm going to go ahead for now and block out.
It's going to be a motion to dismiss and a motion for suppress, and Ken already has his answers. These are all going to be boilerplate. He's seen what I got to say. I've seen what he's got to say. Now we just need you to see what we got to say.
Do you anticipate calling any witnesses?
At the evidentiary hearing?
No.
Or what are we calling it? The motion hearing. Let's call it the motion hearing. Right. Do I have to give you a definitive answer today? Because
No.
I mean, I haven't even clicked into I haven't even put on my motion hat yet.
No, but err on the side of caution. So like if you
Possibly yes. Yes, because I want the case to be over that day. So yes, there is the possibility of me calling 1 or 2 Forest Service officers in there to answer your questions you had that should have never been answered the other day.
All right. So I'm going to go ahead then. I'm going to block out on my calendar, and this can change once we know the nature of the motions, but I'm going to go ahead and set these for March 7th. That'll be our motions hearing. That'll give both parties a chance to file their motions and the other side to respond within time. We'll set it for hearing March 7, beginning at 10 a.m. If we don't need the whole day, that's fine. If we do, then we have it. I will require the parties submit proposed jury instructions to me no later than March 21, and that's something that we can discuss and go over on our pretrial conference on the 25th. But I want to see those jury instructions by the 21st, and also share them with the other party. So not just submit them to me, but submit them to the opposing party.
Ma'am, are you familiar with the full font?
With what?
Full font thing? Are you familiar with the full font thing?
Please, yes.
All right, thank you.
All right. All right, same thing with exhibits. Any exhibits you intend to use during trial, we're going to hash those out also on the 25th. So if there's anything that you intend to display to the jury, we need to see those. Mr. Wahlquist.
Where do I learn the technical nomenclature and all that for the legal nomenclature or whatever of how the format, you wanted an MP3, MP, whatever, it needs to be this thing, a PDF for the jury. I'm talking. Do I bring my own computer? Am I bringing a little stick that plugs into the side of your computer? Do I need to have a paper copy of every digital copy? You know what I'm saying?
Are
That's
you
the rules of evidence, but I'm wondering how this specific court enters it in, because some of them, you know what I mean, want it in person, and some of them want it like filed ahead of time, and so they can pull it up on the screen versus me having the little stick.
Are you talking about exhibits or are you talking about jury instructions?
No, exhibits at trial. You said you said at the pre-trial that a couple days before we would go over all the exhibits we were going to use at trial and enter them and all that. So we did all that ahead of time. And I'm saying the format to enter them, you know what I mean? So when I come on that pre-trial that day, I have all my evidence that I want, my exhibits that I want to enter in the proper format to be entered.
So again, we're not a court of records, so there's not going to be any entry of exhibits, but however you want to display,
Right,
if you want to display them, we do have some technical capability. But if you wanted to go old school and just have big, you know, poster boards of exhibits, that's fine. If you want to get real technical and use your laptop and project it somehow, that's fine too.
That's what I'm trying to say. I need to
Okay.
provide my own laptop, because some courts won't let you bring. They want to use your laptop because you don't want to get a virus and all this. You know what I mean? And so stuff. Yeah, I
So
caught myself just for you, man.
however,
And
yeah,
so-
however you want to exhibit, however you want to present your exhibits is going to be up to you. Just understand that they're going to need to be vetted by the other party. And if there's
Of
any,
course, no. I was more worried about like the technical nomenclature of like getting it from the screen on my computer. Are you gonna have like a big screen up there or something that it shoots to, and then we're watching my lap? Or am I gonna have to like stand in front of the jury holding my laptop in front of their face, or like, you know what I mean?
I have a screen like the
All right.
kind that pulls down, like you can show slides on. But as far as projectors, you're going to have to bring your own.
Well,
if
I
you
mean,
want.
what do you do? Do you plug a cord into it on the side when you know you've done this? What do people bring their laptop up there, plug the cord in the side, and then it's on the screen?
Sometimes that works. But if
Okay.
I can't help you with technical issues, and we don't have an IT department here at the
All right.
courthouse. So be prepared.
We don't need to waste your time on IT either. I'll be prepared.
Okay.
I have a whole field of IT techs.
Okay, good. Mr. Wahlquist, I'm sorry, were you going to say something? Oh, okay. All right, so we will have in the jury instructions, I'll need hard copies of those, or you can send a PDF and we can print them out, but we're going to go over them on paper copies. So make sure that you have any jury instruction that you want included. Typically, in my experience, the state provides those jury instructions for the general stuff. Mr. Wahlquist, what's your practice?
Yes, Your Honor, I'll prepare a packet that I believe has everything, and I'll send that to Mr. Myers. If he wants additional ones, if I'm good with them, I will add them so it's all uniform type and all that sort of thing. If there are any that I would object to, we would bring that up to Your Honor.
Yeah, so I mentioned that because I don't want 2 stacks of complete jury instructions. So what we'll do then is, Mr. Myers.
It'll be kind of like a joint status report. You know what I mean? It's kind of like joint. You know what I mean? Like have the state send me over anything I don't agree with. I'll highlight or something, and then we can, or I want to add something like that. We won't be redundant.
Thank you. That's what I'm trying to get at. All right, so Mr.
No, I know how much court takes paperwork. My wife was a law clerk for a federal judge until something happened, like this case.
All right, so Mr. Wahlquist will prepare the general packet, including the jury instructions associated with the charges. He'll send those for you to look over, and if there's anything you want to add or delete that can't be agreed upon, then that's something we'll take up on the pretrial conference date on the 25th. All right, anything else that anyone can think of before we go?
No, is it communicate with through the LM, right? Everything, all my filings, and then I'm going to serve Kent myself, right?
Yes.
I'm going to serve the court through the filings, and then I'm going to serve court. Excuse me. I'm going to serve the court through that email, and then I'm going to serve Kent how it's supposed to. You know, typically you email them, electronic service, that kind of thing.
Certificate of service. So you're filing with the court and you're serving Mr. Wahlquist.
Yep, cool.
Okay. All right.
Just want to make sure it's thank you for your REBA.
Right. And I will type up the scheduling order and that will be served on both parties. Anything else we need to go over before we adjourn for today?
Your Honor, I think
Oh,
it was
man.
applied and very clear, but you never specifically said it. You're vacating the trial dates on the 13th and 14th of February.
That is correct. I will file an amended scheduling order, but for the time being, the prior dates, including the jury trial dates, are vacated at this point, and we will reset those to March 27th and 28th.
Thank you, ma'am. Good question.
All right. Anything else, Mr. Myers?
I'm all set, ma'am.
All
Ready
right,
to let you get to the next one.
Thank you. Mr. Wahlquist, anything further?
Nothing further. Thank you.
All right. Thank you, gentlemen. We are adjourned.
You too, ma'am. Thank you.
Kent is toast. Kent the legal loser. He's going to hide under his desk and cry. Head back over to Lane's channel. I think he's still alive. Really appreciate you guys coming in and watching the hearing. This needs to happen in the light of day. Public trial. And that's it. Public trial. I'll be in the courtroom for the trial if it gets to that. So, yeah. Love you guys. Later. We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.